then he would be able to make a ruling on the substance. So let me just get this off the board so it doesn't create confusion. So he has to be able to make a substantive ruling about whether Marbury can come to this court or not. And that is a rule of law about whether the 1789 Judiciary Act, or the Section 25 of that act, because the rest of it, I mean, some of it's still in effect now, but Section 25 is unconstitutional, and he has to decide about that. Judges always have to make decisions about process before they get to substance. The weird thing about this decision is that the way the court's written, Marshall puts the process. So let me be clear. When judges write opinions today, they usually have a section in the beginning that says, we have jurisdiction over this case because of X, Y, and Z, and then once we say we have jurisdiction, then once we deal with the process, we will then talk about substance. And notice how deliberately Chief Justice Marshall flips it. He wants to make sure that he has all of these words about substance that are not the legal decision of the case, but he puts on the back end an actual legal decision. The bottom line, the law of the case, is about process and constitutional law judicial review. Okay. Back to Elijah, go ahead.
So does this still happen today, where either the Supreme Court or lower level courts will do this, ever?
This is backward.
This ever happen?
You mean to rule on the merits and then dismiss it for lack of standing?
Yeah, did this ever happen again?
This is totally backward. So let me tell you something I'm working on today. Just when do we go until?
So 11:10. So we have about 13 minutes. It flies by. I know. Yeah.
I know.
You know what? Whatever we talk about is good. That's
So
all that matters.
I'll just say this. I'm the lead amicus. I have an amicus brief for the emoluments cases. Has everyone heard of the emoluments? Do you know what emoluments are? How many
We
people
have
heard?
not gone over that, or what an amicus brief is.
Look, in 60 seconds, on al regel echad, emoluments. There are two parts of the Constitution that say a president can't get gifts or can't get presents or emoluments from foreign governments, and can't get emoluments from state and federal governments. President Trump has hotels that get a lot of business from Saudi government, from other governments, and the question is whether that violates the Constitution. As I've been litigating it, we've won a bunch of cases, but only after they first say that our plaintiffs, as an amicus brief writer, I'm not the lawyer for the plaintiffs, but I come in to say, with 5 other historians, what the word emolument meant in 1787, right? So we're all on the substance. So my brief, I'm all over here, right? We have the lawyers have to argue both. We have other amicus brief writers who are making arguments about standing. It's like jurisdiction. The federal courts don't have jurisdiction unless you can find a plaintiff who has been wronged, who has a right. And the cases we lose, we've only lost, my amicus brief has never been rejected by a court, but the lawyers keep losing in front of only against Republican judges. All the Democratic judges, except for one who've heard it, say that our plaintiffs have standing. All of the Republican judges who've ruled on it say that just a coincidence, I'm sure. Yeah. But my point, Elijah, is today, every decision we read, if the judges say that our plaintiffs don't have standing and then there's no jurisdiction, they don't touch this. So my point is, to answer your question, is Marshall was doing something in 1803 that is the opposite of everything else that we base, more or less, most of what judges do. They say, if we don't have jurisdiction, we're not going to go into dicta about this case. Yes, what's your name?
Josiah.
Josiah, go ahead.
So would you say in Marbury that the court definitely didn't have jurisdiction based on their own ruling?
Well,
did Marbury have standing in the court?
So Marbury didn't. It's standing is a slightly different question than jurisdiction. So let's just pull out the two texts, or let me pull out the constitutional text really quick. Okay, because it's really about jurisdiction more than it's about standing. Let's just separate the two things. Yeah. You could have come to the right court, but you're just not the right plaintiff. And standing is a very particular area of law where it says if you need to have been wronged in a direct way. To be a plaintiff withstanding the most important idea is you have to be a person who was wronged directly, and you have a direct right. And the problem is it's hard with emoluments. When Trump gets money from the Saudis, that might be unconstitutional, but it's hard to find someone who's directly hurt if the Saudis take a hotel room in Trump Tower.
Yeah.
But so does that make sense?
Yeah.
So jurisdiction is just about whether or not you were hurt. You still have to go to the right court. We didn't go right to the Supreme Court with our emoluments brief, right? Or the plaintiffs didn't. They had to go to district court. So if we just turn to Article 3, Section 2, and this is basically what Hamilton, so have you also looked at Hamilton's in the Federalist Papers, number 78? Mm-hmm. So this is basically Hamilton's view, which is the first thing you do is you pull this out. But not this thing, they didn't have this then, but the pocket constitution. And you pull this out, and you line it up with the text of so Section 25 says, we're going to, writ of mandamus, you can go to the Supreme Court, more or less, right? So, Section 13, sorry, Section 13, you can go to the Supreme Court. Well, pull out Article 3, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made, and which shall be made under their authority, to all cases affecting ambassadors, right? This is the original jurisdiction part, right? Cases affecting ambassadors, other public ministers and consuls, cases of admiralty, controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states. Okay, this creates federal jurisdiction, right? Then the next clause is, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Right? So just that clause, right? The list of original jurisdiction is ambassadors, public ministers, consuls, and states. Okay? And then it divides that out with, in all other cases, the Supreme Court shall have appellate jurisdiction. So back to, what's your name again? Josiah, right? Hi, Josiah. This is actually pretty clear. I mean, a lot of our constitutional cases about judicial review are a lot less clear than this. What does equal protection mean? What does due process mean? This is explicit. These are the cases where you can go to the Supreme Court for original jurisdiction, and you can understand why, right? If states are parties suing each other, then what kind of court are you going to go to? It's going to be too much of a conflict of interest if you go to federal courts that are based in localities. So that tells you they were worried about that. But they said, look, everything else, other cases, the Supreme Court has appellate jurisdiction. And a writ of mandamus is another kind of case between two private individuals. So Josiah, like, in a world of judicial review, in the whole spectrum of cases that are clear or unclear, I'm just going to say I feel this textually is a pretty clear problem in Section 13 of the Judiciary Act. Okay. If you go on and study other constitutional law, it's a lot more ambiguous. Yeah, go ahead.
Two quick things. One, when you say it's a win for the Jeffersonians,
yes,
because it limits the power of the government, and that's also kind of paradoxical because it limits the power of the government in that it strikes down the section of the act as unconstitutional,
yes,
but it also massively expands the power of the court by doing the judicial review.
That's
so in some ways it's
exactly right. So this is it, and this is why people missed. So let me just say, people missed this. So when I was reading newspapers. So the question was,
I flipped that over.
Oh, thank you. When I was going back into the newspapers, they didn't see your point. They saw it as first of all, they said, this is just a cop. They were like, who cares? Marbury, it's a 5-year appointment. It's not a lifetime appointment. A JP is basically a guy when, you got two people who have a dispute over a horse. The JP comes in and says, I'm going to talk to someone.
Justice of the peace is JP.
Yeah, justice of the peace.
Now,
Now, even though it has the word justice, that this was a this is not like a justice of the Supreme Court. They have a 5-year appointment, and they basically are deciding whose horse belongs to whom, right? This was petty. This was nothing on their radar, right? But what's your name again?
Shira.
Shira. It turned out that in the middle of this tiny little petty win over a cop in D.C., they buried a bomb.
Yeah.
That's the big move. This just because, and it was 2 bombs. It was jujitsu. It was legal jujitsu. By saying that they didn't have jurisdiction and giving a little win to Jeffersonians, this was a message from Marshall. We're not going to interfere with your move now. We're not going. You stripped all these federal judges out of office. We are, first of all, in this petty decision about a cop,